Hi guys, welcome. I am Nisha Janice. I'm an attorney here in Florida. I've been covering the Adelson saga, the Donna Adelson trial, the Charlie Adelson trial. Today we are here to read through Judge Everett's order on Donna Adelson's motion to suppress her hot mic call, her phone call that was recorded after she gave consent to the jail that Charlie Adelson was in. She failed to hang that call up, so the call continued to record. And it happened to pick up a conversation that she was having with her husband and some friends in her home. So this was just after Charlie Adelson had been convicted for his part in the murder for hire of his former brother-in-law, Dan Markel. We are here for justice for Dan Markel. Where's my banner? There we go. Let's just remember that that is why we're here. I'll say a quick hello to the first person in the chat. Hi, Kate. Thank you for joining me. I'm taking a break from the Karen Reed saga this morning because I promised you guys that I would go live as soon as I had the order. Now, this order was filed yesterday evening, I believe, but it was not available to the public until, well, I didn't see it until this morning. So without further ado, let me share my screen and get that up so we can go through it together. Just a little bigger. Okay. Here we go. All right. Defendants. Wait, this is the wrong one. Hold on. Where is my order? 1 second. This is not it. You guys, I started my stream over, so 1 second. There we go. Oh my goodness, they're making me re-download this and everything. There we go. Here's the order. Okay. Here we go. The order denying defendant's motion to suppress. Thanks for your patience. All right, so this cause comes before the court on defendant's motion to suppress, filed with the clerk on February 10th, 2025. The court having considered the motion, the evidence admitted during the February 26th, 2025 hearing, that one was last week, the arguments of the parties, defendant's supplemental memorandum of law, which they filed after the hearing that was held last week, the court file, and being otherwise fully advised in the premises, finds and adjudges as follows. Background. On November 7, 2023, defendant received a phone call from the Leon County Jail to her cellular phone while she was at home in her apartment. The caller was her son, Charles Adelson. At the time, Charles Adelson was an inmate of the Leon County Jail, incarcerated there since his arrest on April 21st, 2022. 1 day prior to the phone call at issue, Charles Adelson was convicted of first-degree murder, conspiracy to commit murder, and solicitation to commit murder. Hopefully YouTube doesn't get me for saying that so early in the stream. Before being permitted to speak with her son, defendant was required to acknowledge the following message and consent to its terms. Now, after I read through this order, we're going to go back and watch the arguments that were given at the hearing and listen to the judge and his questioning of the defendants, the defense counsel. You hear that this is one of the judge's main questions, this question about, didn't she give consent? So the message disclosed Hello, this is a prepaid collect call from Charlie, an incarcerated individual at the Leon County Jail. This call is not private. It will be recorded and may be monitored. If you believe this should be a private call, please hang up and follow facility instructions to register this number as a private number. To accept charges and consent to this recorded call, please press 1. To repeat, thank you for using Seqaris. You may start the conversation now. This preamble is the standard notification advising individuals who receive phone calls from Leon County Jail that the calls will be recorded. Thus, to speak with a Leon County Jail inmate through this phone system, the non-inmate must give consent to being recorded unless it is a private call. Defendant concedes she was informed of this notification when she consented to speak with her son on the recorded line. Approximately 8 minutes into the phone call, Charles Adelson was disconnected, leaving only defendant's phone still being recorded by the Seqaris phone system. At that point, defendant said, "Can you hear me, Charlie?" "Shh, you can't hear me again, right? Charlie, can you hear me?" "I'm sorry." The fourth time that they cut the line each time. She then began a lengthy conversation with other people who were inside of her home. Footnote 1, let's see what that says. Footnote 1 says those people were her husband, her attorney for her estate planning, Susan Brotman, and Miss Brotman's husband, Richard Chagrin. Defendant testified that Mr. Chagrin is not an attorney. While the issue of privilege is not raised through this motion, a recognized privilege can be waived by voluntary disclosure or consent. Given that defendant was conversing with people other than her son, referring to her son as he and him while talking about him, and revealing facts she did not, quote, have the heart to tell him, the court is convinced defendant subjectively believed their shared phone call had ended and any ensuing conversations private. Subsequently, over the next 15 minutes, defendant alluded to committing self-harm. Confessed she was looking for countries that did not have extradition agreements with the United States. Wondered whether Vietnam has an extradition agreement with the United States, and spoke about a conversation she had with her daughter, Wendy Adelson, about giving her, quote, papers and wills. Eventually, someone other than defendant realized that the phone call had yet to end and ended the call. It was only at this point that the phone call terminated and the recording stopped. Investigator Jason Newland testified, "This is standard protocol for phone calls originating from the Leon County Jail." Defendant argues it was an unlawful, warrantless interception to record her conversation after Charles Adelson was disconnected because she believed the phone call and recording had ended. Analysis. Before trial court will consider, quote, the merits of a Fourth Amendment motion to suppress, the defendant must first establish a factual basis justifying his or her claim to have possessed a Fourth Amendment right at the time of the alleged invasion. Regarding oral communications, quote, for an oral conversation to be protected under Section 934.03, the speaker must have an actual subjective expectation of privacy, along with a societal recognition that the expectation is reasonable. Accordingly, quote, to successfully claim the protection afforded by the Fourth Amendment, a defendant must demonstrate that he or she personally has an expectation of privacy, and that this expectation is reasonable. Defendant argued in her written motion that the state bears the burden of justifying its alleged warrantless interception and moved to suppress the oral communications she uttered after Charles Adelson was disconnected from the phone call. However, the written motion misstated the burden of proof because, quote, a Fourth Amendment search does not occur even when the explicitly protected location of a house is concerned. The individual manifested a subjective expectation of privacy in the object of the challenged search, and society is willing to recognize that expectation is reasonable. And that's quoting a U.S. Supreme Court case from 2001. As a result, it is the defendant who must first establish a search occurred within the meaning of the Fourth Amendment. Therefore, let's go to footnote 2. Let's see what that says. Footnote 2 says, at the hearing, defendant conceded she bears the initial burden of establishing a subjective expectation of privacy that society is prepared to recognize as reasonable. Following the court's finding that defendant established a subjective expectation of privacy, Donna testified that she thought she had that privacy while she was speaking with her husband and her friends in her home. The court remarked that the burden shifted to the state to establish society would not recognize her expectation was reasonable. Upon further review of the relevant precedent, the court concludes defendant also bears the burden of establishing society would be willing or prepared to recognize her subjective expectation was reasonable. Both parties were permitted to argue the issue of whether the subjective expectation of privacy was reasonable during the hearing. So we're going to see in the hearing that Donna testified that she thought she was having a private conversation. Judge Everett in that hearing mistakenly said, okay, now Donna has testified to that fact. Now the state has to show that society also believes that Donna's expectation of privacy was reasonable. So in this document here, he's correcting himself and saying, actually, the defense, Donna, has to prove both elements. She has to prove both that she had a subjective expectation of privacy and that society, as a whole, also would believe that her expectation of privacy was reasonable. All right, let's go back up. Therefore, to support suppression of a communication under the wiretap law, the person who made the statement, Donna, must show more than a subjective expectation of privacy. They must show that they have a reasonable expectation of privacy under the circumstances, which depends on one's actual subjective expectation of privacy, as well as whether society is prepared to recognize that expectation as reasonable. Because the court concluded defendant did subjectively expect that her conversation was private, this motion turns on whether society is prepared or willing to recognize such expectation as reasonable. After conducting a thorough analysis, the court has determined defendant's conversation did not constitute the unlawful interception of an oral communication under Section 934.064 of the statutes. Reasonable security measures of Leon County Jail. To ascertain whether society is prepared or willing to recognize defendant's subjective expectation of privacy as reasonable, the court begins with the well-established principle that citizens are guaranteed a reasonable expectation of privacy in their own home, right? We can all agree to that. The court also recognizes that jails and correctional facilities have a strong interest in preserving and maintaining their security, and, quote, the interception of calls from inmates to non-inmates does not violate the privacy rights of the non-inmates. Let's see, this is quoting a Southern Third case in which Jackson versus State. 1, Jackson did not have a legitimate, reasonable expectation of privacy in a recorded phone call that was placed while incarcerated after receiving warning that the call was being recorded, like in this case. And 2, the interest in institutional security allows jailhouse conversations to be monitored. In addition, it does not matter if the call is made to a non-inmate's home. Quoting this case, Willoughby, that says, nor do we find merit in Willoughby's contention that his own privacy rights were entitled to greater protection than those of Quinton because he received Quinton's call in his home. Thus, defendant Donna relinquished her reasonable expectation of privacy when she answered her phone and consented to speak with her son. Defendant argues that she regained a reasonable expectation of privacy, which was previously relinquished through consent, once her son was disconnected, but she did not actually terminate the phone call from her end. During the hearing, the state contended that the primary basis for denying defendant's motion to suppress was that it did not intentionally record defendant's conversation. Footnote 3. Footnote 3 says the state also argued defendant did not have a reasonable expectation of privacy, arguing that the reasonable expectation only begins once a person actually hangs up a phone. Seems reasonable, right? The court disagrees. So, okay, wait, what does the court disagree with? The court disagrees that the state contends their primary basis for denying defendant's motion to suppress was that it did not intentionally record defendant's conversation. The court disagrees. The Leon County Jail intentionally utilizes technology developed by the company Sicaris that, by design, continues to record conversations between inmates and call recipients until both parties disconnect. If the decision to record prior to the inmate's disconnect is intentional, as the state's argument concedes, it stands to reason the decision to record after the inmate is disconnected is also intentional. However, in determining whether an expectation of privacy is reasonable, courts should examine the location of the conversation, the type of communication at issue, and the manner in which the communication was made. Although the location of the defendant's conversation occurred within her home after her son was disconnected, the fact remains she consented to receiving a phone call from a jail facility. The type and manner of the communication are also quite different from ordinary phone calls. This phone call, 1, began with a message stating it was not private. 2, required acknowledgement that it was being recorded. 3, required consent to proceed. And 4, utilized third-party technology to facilitate recordings between inmates and non-inmates. Even if many modern cellular phone devices typically terminate a phone call when one party is disconnected, as defendant stresses, communications from jails and correctional facilities have unique institutional safety concerns that are not at issue in common communications between non-inmates. Thus, defendant's subjective expectation was built on a false assumption that dropped calls involving the Leon County Jail have the same result as dropped calls involving at least one cellular phone. Footnote 4. Footnote 4 says, on this point, defendant's hearing testimony was inconsistent, where she acknowledged a belief that calls from the Leon County Jail end whenever an inmate is disconnected, while also admitting she hung up her phone each time Charles Adelson was previously disconnected before November 7th, 2023. Whether defendant forgot to hang up her phone or assumed it was unnecessary, society, us, would be unwilling to recognize her expectation of privacy was reasonable under either circumstance. All right, this assumption is unreasonable given the concerns correctional institutions and jails encounter. For example, a federal court of appeals has remarked that the Bureau of Prisons recording system and the random live monitoring of telephone conversations have assisted in the detection of escape plans, of schemes to smuggle controlled substances into the facility, and of inmate identification of another inmate as an informant in the government's witness protection program. There is no plausible reason why the Leon County Jail should not be afforded deference in how it uses a recording system to safeguard against similar security concerns, including by continuing to record an inmate's phone call until both parties have disconnected the phone call. Quoting a U.S. Supreme Court case, Bell versus Wolfish, prison officials must be free to take appropriate action to ensure the safety of inmates and corrections personnel and to prevent escape or unauthorized entry. Accordingly, we have held that even when an institutional restriction infringes a specific constitutional guarantee, the practice must be evaluated in the light of the central objective of prison administration, safeguarding institutional security. Security risks do not dissipate when only the inmate disconnects the phone call. In the ever-evolving technological world, inmates and non-inmates can exploit loopholes to circumvent institutional safeguards. Some inmates evade or break the rules restricting the privileges. For example, the department's telephone security vendor can detect three-way call attempts by the clicking noise that occurs when a call is transferred, but inmates will blow into the receiver when transferring a call to mask that clicking noise. And as the federal courts have opined, it is difficult to imagine that the considerations that justify monitoring and recording of a prisoner's utterances could somehow not apply at the other end of the telephone. The rights of free persons may well at times be implicated and stand or fall with the rights of prisoners. Defendant's subjective expectation conflicts with her own knowledge. Charles Adelson was arrested on April 21st, 2022. The portion of the conversation defendant seeks to suppress occurred on November 7th, 2023. That period spans a difference of 565 days. Based on the sheer volume of calls, footnote 5 says investigator Newland estimated there are thousands of calls between defendant and her son while he was incarcerated at the Leon County Jail. So, based on the sheer volume of calls between defendant and Charles Adelson, she cannot reasonably claim to have been unfamiliar with how the Leon County Jail facilitates phone calls from inmates. This asserted subjective expectation became less and less reasonable with each time she answered a phone call from the Leon County Jail, consenting to recorded calls until both parties are disconnected. She cannot even claim to be unfamiliar with what transpires when a Leon County inmate's phone is disconnected because she is heard acknowledging on the November 7th, 2023 recording that her son had been disconnected for the fourth time. Defendant testified her son was frequently disconnected during the phone calls he made from the Leon County Jail. During these other instances, defendant answered she would ordinarily, quote, hang up the phone after he was disconnected, suggesting she realized she needed to hang up her phone to end or terminate the calls. Thus, rather than expecting her phone would automatically disconnect, her own testimony reflects that she was aware that calls from the Leon County Jail would continue unless and until she hung up her phone. Expecting an opposite result or outcome from what had taken place previously and repeatedly is an expectation society is unwilling and unprepared to recognize as reasonable. This Huff versus Spa case says a person who knowingly operates a device that is capable of inadvertently exposing his conversations to third-party listeners and fails to take simple precautions to prevent such exposure does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device. See also United States versus Monger, the Ninth Circuit case. Any expectation of privacy in outbound calls from prison is not objectively reasonable, and the Fourth Amendment is therefore not triggered by the routine taping of such calls. Conclusion: for these reasons, the court cannot conclude society, that's us, is prepared to recognize as reasonable defendant's subjective expectation of privacy in the November 7th, 2023 phone call. 1. The phone call was received from a jail or correctional facility with a valid interest in preserving security by continuing to record phone calls until both parties of the call have disconnected their phones. 2. Defendant's subjective expectation was contrary to her own familiarity with the Leon County Jail phone technology and prior use-based knowledge. And 3, expecting different outcomes or opposite results from what has repeatedly occurred is intrinsically unreasonable. It is ordered and adjudged that defendant's motion to suppress is hereby denied. Done and ordered in Leon County, Florida on Monday, March 3rd, 2025. Stephen Everett. All right, y'all. Okay. So there you have it. Clear as black and white, right? This is not surprising at all. It's not surprising at all. So it boils down to Donna may have had an expectation of privacy, despite her knowing that she had to hang up the phone call. She knew from her prior experience with those types of phone calls where Charlie had dropped that she still needed to hang up her call, her end of the conversation. She'd done it in the past. And the hot mic picked up that this was the fourth time that this was happening. She hung up in the past. For some reason, she didn't hang up this time. And next, the second prong is whether we, us collectively, society, believe that her expectation of privacy was reasonable. And the judge said no. No. Him, Judge Everett, he also does not think that it was reasonable for her to think that that she was having a private conversation. All right, let's go to the chat real quick to say hello. I said hi to Kate first in the chat today. Hello. Good morning. Hello, much better today. That's always good to hear. Much better today than yesterday. Things can only go up, right? Hi, Kenor Spellman. Thanks for joining. Pray Then Hustle. Love that name. I can't remember what call she is trying to suppress, but it must be pretty damaging. It is pretty damaging. The court in the background section, I think they pick up the things that they believe are most damaging. We see defendant alluded to committing suicide. She professed she was looking for countries that did not have extradition agreements with the United States. She wondered whether Vietnam had an extradition agreement with the United States. She spoke about a conversation she had with her daughter, Wendy Adelson, another unindicted co-conspirator, about giving Wendy her papers and wills for safekeeping, estate documents, right? So that's some of the damaging information that was in that hot mic call. Kidor Spellman says, Charlie's disconnected in more ways than one from normality. Yeah, you know that. You know that's right. Oh, that call. Yeah, that call. She'll not get bond based on that call. Yeah, so now that that call is in, it's not being suppressed, the judge can rely in part on that call, as well as all the other evidence in his ruling for bond. So yes, hi T. Cancella. I did see that Donna and her counsel are intending on deposing Sigfredo Garcia. That was also, it was actually uploaded yesterday, but it became available to the public today. So Sigfredo, if anybody doesn't recall, is the gunman. He is actually the one who wielded the pew pew and did the deed in cold blood. He is Katie McBanoa's children's father. They were in a relationship, and Katie McBanoa was in a relationship also of sorts with Charlie Adelson. Charlie Adelson, of course, the son of Donna Adelson. So, yeah, that will be very interesting. That will be very interesting. We'll see what he has to say and probably see him at trial. So what I wanted to do next was just go to the hearing, actually, and just rewatch the arguments of the attorneys on that motion to suppress. And it's about 20 minutes, but I think I'll watch it probably 1.25 speed because nobody has all day, right? But it'll be interesting to hear Judge Everett's questioning of the attorneys. And, oftentimes um, when you're in court and the judge is asking those questions in a hearing, you're able to see which way uh, he or she is leaning, in terms of ruling. So let's go over to that. All right, here we go. This is just as Donna is getting off the stand.
As to the burden at this point, under the precedent established by Smiley versus State, in order to exclude what are complained of wiretap interceptions, the movement has a need to show there was a subjective expectation of privacy in their statements, and the expectation is one that society would accept as reasonable. As to the subjective expectation showing, the defendant has met that burden that now shifts to the state as to whether this is one that is reasonable. Stephen?
Yes, sir. I have argument.
You may proceed.
May I provide the court with some case law?
You may.
I've got some argument, and then I'm going to go through each one of these cases. I provided a copy of each of this one.
Slow it down just a little bit. So Donna Adelson says she testified that
The defendant's motion, they first argued that this was a warrantless search. However, the state's argument is that this is not subject to Fourth Amendment. There's no wrongful state action that caused this defendant to be reported after the inmate was no longer on the call. The only conceivable state action here was the state having this service that allows inmates to make recorded calls. But on those calls, both parties have to consent to be recorded for the call to begin. And if they do not want to be recorded, I need to hang up. The state didn't intend to record this defendant's conversation in her home with her husband and friends. And it was the fact that she was recorded was not caused by the state's actions. It was caused by the defendant's actions. The defendant argues that they have this reasonable expectation of privacy in the call, but that would only start once this defendant actually hangs up. And the defendant is the one responsible for hanging up, not the state. The defendant was responsible for the interception of the phone call. It was her failure to hang up that caused that rest of that call to be recorded. It was her action and not the state action that made that happen. The state did nothing to keep her from hanging up the phone and prevent her from hanging up the phone. I think an analogy here would be if someone were to say something incriminating in earshot of a law enforcement officer because they think the law enforcement officer can't hear them. If they can actually hear them, then that's on the speaker because the speaker didn't walk away at the top. That was the speaker's carelessness. The defense also cites Florida Statute 934 and says that the good faith exception doesn't apply because this call was in violation of that statute. But when you look at 934.03, every single subsection of that statute applies to intentional intercepts, not accidental. I provided several cases to the court. There's nothing directly on point here of this situation having happened just like this in the past, but there are a lot of cases that deal with inadvertent recordings. One of the first cases I gave to you is Baronet. This is a U.S. Court of Appeals case from the Sixth Circuit that held that police interception, conversations between the defendants that was overheard when a telephone that was subject to a court-authorized wiretap was inadvertently left off the hook by the defendant. That was authorized under the plain view exception to the warrant. In that case, the state had an actual Title III wire on the defendant's phone. The defendant was on a call and then didn't properly hang up the call. They left the phone off the hook accidentally. And then law enforcement was able to hear the conversation in the room where that phone was located. So when you compare that to our case, there's obviously a much different type of state action in that case with the wire. But regardless, this was a recorded line. It was a legally recorded line where they consented to be recorded. Just like in our case, though, the defendant in that case failed to properly hang up, and that allowed law enforcement to hear the conversation in the room. And that was able to be authorized because of the inadvertent nature of the recording. Another was Otero versus State. This is a pure DCA case from Florida where a child accidentally activated an answering machine of a home that she was staying at. And that answering machine recorded the conversation of the mother and the child unbeknownst to either of them. The third DCA found that admission of that tape into evidence did not violate the statutory exclusionary rule found in 934 because 934 prohibits intentional interception of wire communication. And that taping in that case was accidental, not intentional, just like in our case. There's another case that I provided to the court, Bell versus State. In that case, a girlfriend began to record her conversation with her boyfriend, who was the appellant. And that conversation that she wanted to record was about money, an argument about money between them. The appellant, Bell, then took the phone from her and kept the phone after the argument ended and the girlfriend left the house. The girlfriend's young daughter was still at the house, and after the girlfriend left, the defendant was intoxicated and forgot to turn off the audio recording. There was then a recording that, as the recording kept going, it recorded him molesting the girlfriend's young daughter after the girlfriend left the house. The girlfriend then discovered the audio recording next day and handed it over to the police. The defendant was charged with L&L molestation. In that case, the recording of this molestation was obviously inadvertent, and the defendant agreed with that. Only the first conversation about money was what the girlfriend was trying to intend before the phone was taken from her. And that phone was in the appellant's custody and control at the time of this recording of the L&L molestation. The DCA in that case said that the trial court did not err in concluding that Mr. Bell failed to prove that his girlfriend intentionally intercepted the portion of the recording while she was gone. Unless his girlfriend intentionally violated the statute, he was not entitled to the benefit of the statutory exclusionary rule. Because the recording was not surreptitious, but after she warned him she was going to record him, he took possession of the device that recorded his words and actions. And so the court found that the appellant did not establish that the communications were intercepted under any circumstances justifying an expectation of privacy. I have one more case that concerns the reasonable expectation of privacy. This is the Hub case that I provided to the court, which is a federal case where the plaintiff, a federal civil case, where the plaintiff inadvertently pocket dialed the defendant, which is something that has happened to us all. And the defendant listened to and recorded the conversation she overheard while on the pocket dial call. The plaintiff then brought suit for the defendant intentionally intercepting this private conversation. And in that conversation, the plaintiff was basically having a discussion with his wife and with other people as well. The court ruled that the plaintiff's statements did not qualify under Title III because he exposed them to the defendant when he pocket dialed her. But the plaintiff's wife's statements did qualify. She can't be held responsible for her husband's pocket dial. But the thing that I think is most important about that case is the court's holding that a person who knowingly operates a device that is capable of inadvertently exposing his conversation to third-party listeners and fails to take simple precautions to prevent such exposure does not have a reasonable expectation of privacy with respect to statements that are exposed to an outsider by the inadvertent operation of that device. So in that case, the statements didn't qualify as ones that were protected under the U.S. Code. And that's what we have here. We have the defendant failing to take simple precautions of properly hanging up what she knows is a recorded call. So the state would ask that the defense motion be denied.
Final argument on the motion to suppress from the defense.
Yes, Your Honor. There are two cases, cited a number of cases. I know Your Honor's practices review those in addition. There are two additional cases I provided copies to the state that I rely on. Versus Hentz versus State, 62 Southern 3rd, 1184. State versus Mozo, 655 Southern 2nd, 1115. May I approach?
You may.
So, Your Honor, I want to start with a very general proposition that's important for us to remember. Right to privacy is enshrined in the Florida Constitution. Article 1, Section 23 provides the right of the people to be secure in the persons, houses, papers, and effects against unreasonable searches and seizures and against the unreasonable interception of private communications by any means shall not be violated. Article 1, Section 23, the Florida Constitution also provides that every natural person has the right to be let alone free of governmental intrusion into the person's private life. The Fourth Amendment includes similar protections. 934.02 defines an oral communication as any oral communication uttered by a person exhibiting an expectation that such communication is not subject to interception under circumstances justifying such expectation. The courts have held in Florida, as cited in my motion, for an oral conversation to be protected, the speaker must have an actual subjective expectation of privacy along with a societal recognition that the expectation is reasonable. Your Honor, State versus Mozo, almost 20 years ago, courts have held that conversations, oral communications taking place in one's home are protected by Chapter 934.
I don't think this point is reasonably in dispute, but go ahead.
Now, the question, obviously, is the objective portion of this test. Hentz versus State, 4th DCA. And Hentz is a situation, Your Honor, where an individual was in an interview room at a police department. He placed a call to essentially a co-conspirator, co-defendant. And the recording equipment was powerful enough in that interview room to pick up the other end of the call that is made to Hens. Based on what law enforcement heard from the individual's call, the individual who was calling Mr. Hens, they obtained a search warrant for his cell phone. And on that cell phone, they found images that are able to possess, as well as other evidence of a crime that the two of them engaged in. The Hens court held that, and another important factor, Your Honor, Mr. Hens was aware that the individual on the other end of the phone was at the police department, waiting to speak to law enforcement. Court held that Hens had a subjective expectation of privacy, and his expectation was one society accepts as reasonable. Now, one distinguishing factor I need to acknowledge is that, but I submit it's not this positive, is that while Hens did not know that the individual was sitting in a police interview room, whereas Mrs. Adelson knew that Charlie was in jail and had consented to her call with Charlie being recorded. But the oral communication that is protected by Chapter 934 that is at issue here are the conversations that Mrs. Adelson had after Charlie dropped off the call, when she believed the call was no longer being recorded. Conversation, at least with respect to November 7th, is with her attorney and her husband. Both are confidential relationships.
Doesn't the warning, though, about the recording almost directly speak to that issue where, I'll read the case that you've given me about Pence. Although he knew his friend was at the police station, he never received an explicit warning about you may be recorded if you continue on this conversation.
Correct, and I'm going to get to that.
Go ahead.
Thank you. The testimony, uncontroverted testimony, is that Mrs. Adelson believes she hung the phone up once she realized Charlie was on the phone. There's no evidence otherwise. And I don't think it is reasonable to require an individual in a situation like that, I recorded a phone call, let me repeatedly hit the end button.
No, you have to hit it once.
It should be enough.
You do have to hit it, though.
That she ended up. Now, Hens also addressed something else that I think is important. Chapter 934.03 is a general intent statute. It does not require that the state intentionally recorded after one party of this jail call drops off. It's not required. Wasn't the system designed to intentionally record? The answer has to be yes. Investigator Newland testified, yes, intentionally designed to record. Now, the state, I anticipated that they would argue accident or inadvertence. This is not an accident. An accident is something that doesn't happen frequently. Mrs. Adelson testified this happened. The call, Charlie dropping off the call would happen frequently. As Investigator Newland acknowledged, Defense Exhibit 3 and Defense Exhibit 1 established, this was not an isolated issue. This happened. The system is intentionally designed to continue recording. Under Chapter 934, I submit that when either side of the call is no longer on the call, that the system has to stop recording, and any additional recording is a violation. That's what we have here. This is not an accident. This is not inadvertent. Securest Technologies system is designed to continue to record after either one of those parties drops off the call. Investigator Newland said that it terminates when both parties hang up. Well, I submit, Your Honor, that that's not what happens. It continues to record, and it is not reasonable. And society is not expecting that somebody sit there with their phone and continue to hit the end button to make sure that the call stops on their own. I think that's
But do you have to continue to hit the end button?
No.
Or you hit it once and it's disconnected?
Once and
testimony
done.
is that she believes she did.
But she didn't. It's not believed.
So because this is not a specific intent
What am I
statute,
missing?
is the system designed to intend to record? Yes. And there's no evidence that this was accidental or inadvertent. This is not a pocket dial, as the state argued. We know that Charlie intentionally called his mom. We know that the system intentionally recorded the call. The state has not presented sufficient evidence to establish this is not a communication that society is, that there's a reasonable expectation that society would accept that this call is anything other than something that is entitled to protection of 934 and the Constitution.
Mm-mm.
And we'll review the cases that were presented by both parties before making any ruling. I'll reserve on the ruling as to today. We'll take a brief 5-minute break before we get into the Arthur and bond motion. We'll be in recess.
Thank you.
So, defense counsel was right about one thing. They did win one facet of the argument. The state had been arguing that the recording of Donna after Charlie dropped off was inadvertent. It was like a pocket dial, remember? And Donna was like, oh, I don't know what a pocket dial is, or what dial is. Well, the judge didn't agree. The judge said, basically in his order, hold on, let me read it so that I don't get it wrong. Okay. During the hearing, the state contended that the primary basis for denying defendant's motion to suppress was that it did not intentionally record defendant's conversation. The court disagrees. The Leon County Jail intentionally utilizes technology developed by the company Sicaris that by design continues to record conversations between inmates and call recipients until both parties disconnect. If the decision to record prior to the inmate's disconnect is intentional, as the state's argument concedes, it stands to reason the decision to record after the inmate is disconnected is also intentional. So the judge is basically saying the system, the phone system, is designed to record. Period. Nothing was unintentional. It's designed to record until both parties hang up. And that is no shocker at all, right? What he did say is basically it's unreasonable to believe that if you don't hang up, anything else that you say is private. Not believable. It's not believable. It's not reasonable to believe, to have that belief. That's basically what this motion to suppress was denied upon. Let's get back to the comments, and then I'm going to let you guys go. Thank you for joining me again. Hi, 789 Theo, back with the Adelson mischiefs. Yes, absolutely. Yeah, wondering why they are deposing Sigfredo Garcia. At this point, I think they're just trying to get as much information as they can get. Sigfredo, he hasn't talked. So we don't know what he's going to say. Maybe they're hoping that he can support some angle of extortion or something like that. Maybe that's possible. I don't know. Sigfredo hasn't spoken at all. So I think they're probably just grasping for whatever they can get at this point. Their case is not going well. It's not going well. It's not looking so good for Donna. And like I said, I think based on this motion being denied, based on the ability to consider this hot mic phone call, her bond is also going to be denied. But, things have gone sideways before, but that's just how I'm seeing it going right now. Yeah, Lynn, same. But unfortunately, we're not going to because it's going to be by written order. She's going to be in her cell somewhere, and I don't know, she'll probably get a phone call, or she'll probably be calling her attorneys to find out if he's ruled yet, and hear it from them, or hear it from Harvey or whoever calls. So no, he has not ruled regarding the bond yet. Yeah. Kate's asking, do we know yet who will testify at trial? We have a good idea of it. I don't have the actual list in front of me. it's a lot of the individuals that testified at Charlie's trial are on it. Um, there's some additional people as well. And the list that was previously submitted under Rashbaum, that could change. I believe that could change. We have a new discovery deadline, um, post Rashbaum. So we may get an amended witness list at some point. Is it rolling? Yeah, I don't know about that. I don't think that that's the case. I don't know who's saying the bond ruling isn't going to be made until Monday. He was taking everything under advisement, so I fully expect to see a written order soon, any day now, any day now. Hey, Brittany, hi. Is Charlie ever going to file his appeal? Yes, yes. I think he will file an appeal. I think they are trying everything that they can to um, to not have it come to that. They most recently had a motion for new trial be denied by Judge Everett. Um, Judge Everett basically, see, we don't know exactly what happened because the documents aren't available for public. For some reason, they're like under seal or something. So I wasn't able to read the substance of those documents. But the docket in Charlie's case at the trial level did say that the motion for reconsideration or for new trial had been denied. So I'm not sure what the next step is. I may have to go in and look to see if any dates had been set in the appeals court, but I am checking regularly and nothing has been filed since, I believe, January 6th. Brittany's also asking, did I see a new attorney entered his appearance on Sigfredo's docket? I did not see that. Who is this new attorney? And is it possible that he's just going to be represented at his deposition, possibly? I mean, it might be a good idea to have some representation. It's always a good idea at a deposition to bring your own attorney, because nobody else will be looking out for your interests at the deposition. So I'm not surprised to see that, but no, I didn't see that. Thanks for telling me. Thanks for letting me know. I haven't been checking Sigfredo's docket at all. Hi, Tech Class Hero. Tech Class Hero is asking, would the judge set a precedent if he rules her able to achieve bond due to bad ears, carb-heavy diet issues, and unscrupulous inmates? Oh my gosh. Probably, because that would be unheard of. I don't think bond is going to be based on any of those things. Listen, Judge Everett said it months and months and months ago. Jail sucks. So he's fully aware that the meal plan is uh, less than carb favorable, and there are some, you know, unscrupulous people that are being held in jail who may be up to their own devices and may have bad intentions for other people, but that's what you get in jail. It's not a punishment. You're not being punitively put in there, but you're being put in there, for the safety of everybody and to ensure that you don't, run away, to ensure that you are there on the day that you have to stand trial um, for the charges. Mike Mann. Mike Mann. entered his appearance for Sigfredo Garcia on February 19th. Never heard of the person. Interesting. All right, thanks. Kate said, too many carbs and too much earwax. Yeah. I mean, you did hear her say that she orders her tuna fish, chicken of the sea. So at least she's getting some protein. What is this? Lynn says the desperation with Sigfredo is on Monday, 10 a.m. by Zoom March. Oh, the deposition of Sigfredo. Yes. Yes. That's coming up by Zoom on March 10th. And they held the depositions of, I forget the names of the ladies, other inmates of Donna, who supposedly had information about what Katie McVanawa told them. I can't remember their names. I did a post about it though. Let me see real quick. Brittany Purcell and Cassidy. They should have been deposed on February 28th. So, they may be added to the witness list at trial. We'll see. We'll see. Anyways, that's all I have for you guys today. I just wanted to share the substance of that order with you. And once we get the order on the bond, I will also read that for you, and we'll go from there. We'll see what's next in this crazy, crazy story. But that's all I have for you today. Thank you for joining. Thank you for hopping on this live that's unscheduled. I mean, I feel like all of my lives are kind of unscheduled, but look, we're busy. So I'm glad that you had an opportunity to get on with me and engage. I love the engagement. I love the questions and the comments. That's what makes it fun for me. So hopefully I will see you soon again. All right. You have a great day. All right. Bye.